We'll be discussing the law that regards to restaurant and bar liability for intoxicated patrons who harm third parties. This could include any sales to individuals that are too intoxicated, underage, etc. If a facility sells alcohol to someone who doesn't meet the standards of legal drinking, the facility will be held liable for any damage caused. For example, if I serve an intoxicated individual more alcohol and later they get into a fight, I can be deemed liable for the damages. This is called the dram shop liability law. So the law states that if someone is obviously intoxicated or under the age of 21, it is unlawful, and if you sell to them, it will be a violation of the law. So if the intoxicated individual causes damage, death, or any harm to another person or property damage, it will go back on the business and they will be held liable. So basically, this allows the victim to file civil lawsuits against the business for being negligent and or the person who served the alcohol, as well as the intoxicated person. So they would be able to get compensation from both parties, which increases the available insurance coverage overall. The term dram refers to an 18th century British way of measuring a quarter pour. Dram shops are originally taverns or bars, so the whole idea originated from the English common law. Originally, it was introduced during the temperance movement. So this social movement against the consumption of alcoholic beverages lasted from 1920 to 1933 in the United States. This at first started with the idea that alcohol should just be taken in moderation and that patrons should help each other to limit themselves, but eventually it led to the Prohibition Act banning alcohol completely. So even though alcohol was made legal again, the dram shop law kind of extends off of the original ideas that alcohol should be drinking in moderation and that patrons should be looking out for one another. So a first-party dram shop case is where the plaintiff is the intoxicated person and caused harm to a third party. Really, this would only be valid if the person was a minor and their intoxication is a result of being served alcohol at a bar or restaurant. In comparison to this, there would be a third-party dram shop case, which would mean that the plaintiff was the person who sustained the injuries as a result of the intoxicated person. So they would be able to sue the business and possibly even the intoxicated individual. Obviously, everything does vary case by case and depending what state you're in, but most likely they will be able to get compensation from both parties. One of the first recorded cases of the dram shop liability law can be traced back to 1806. This took place in England, and a tavern owner was found liable for serving alcohol to an already intoxicated individual who then later was harming others. Another one of the earliest recorded cases happened in 1848, Hurley versus Eddingfield. So the court basically held the bar owner responsible for serving alcohol to an intoxicated individual who then went out and was hurting others. So this really was significant because it established the principle of duty of care for alcohol establishments. Another case happened in 1991 in New Jersey. This was Rappaport versus Nichols. So this case established that establishments could be held responsible for serving alcohol to someone who is visibly intoxicated, even if the person was not yet legally intoxicated. So the court emphasized the importance of preventing potential harm and acknowledging that serving alcohol to someone already showing signs of intoxication could contribute to their impaired judgment and decision making. So these early cases really had a huge impact on shaping the laws that we have today, and they do continue to modernize as time goes on and society changes. So establishments are advised to implement policies and procedures to prevent overservice, such as limiting the number of drinks served per customer, or refusing service to individuals who exhibit signs of intoxication, like slurring and falling over, etc. So bartenders and servers are now trained to recognize the signs of this and to help protect everyone in the establishment, including themselves. It's really crucial that businesses really put importance on making sure that their staff is aware of the signs to help avoid lawsuit and injuries even for their own staff. It's a really important law because people can easily be injured, and it's important that their staff is paying attention and knows how to recognize when to stop serving someone. So this case is from 2010 and took place in North Carolina. It involved two individuals, Matt and Meredith Eastridge, who were victims of a drunk driving accident caused by David Huffman. Police reported that Huffman was going over 100 miles per hour and his blood alcohol content was 3 times the legal limit. The victims spent over a month in the hospital, lost their unborn baby, and faced extensive surgeries. The defendant's attorney tried to argue that the bar had arranged a driver for Huffman, but he took his car anyway. It was proved that he had over 15 drinks in 2 hours, and the bar was then deemed liable as a result of negligence, and the Charlotte jury returned a $1.7 million verdict against Eddie's Place, the bar that served him. In conclusion, the dram shop liability law holds establishments accountable for over-serving individuals. The law has changed, developed, and adapted to modern times since its beginning standards, but it is very important that the establishment can recognize the role that they play in the harm of others. Unfortunately, there are so many alcohol-related instances, and the purpose of this law is to push establishments to do what they can to help avoid these accidents and keep everyone safe.